I was just at a symposium where they were doing 7-minute sessions and they were speed talking. We'll see if Brandon can keep up.
I mean, your office, sorry, they done.
No.
Oh.
Like 4 more weeks. So we make sure that it looks like. Yeah, 4 more weeks, but it's worth it.
Yeah.
Well, we're all here and I see Brandon's on the up. Do we go ahead and get started? Oh, great. Hi, Brandon. Before you get going, Brandon, I just thought we'd all take a minute to introduce ourselves because, we've got some new faces and, maybe just say like who you are, how long you've lived in Lyons. That'd be good. Anything else you want to say about yourself? Yeah.
Sounds good. You want me to go?
Yeah, you want to start, Phil?
Hi, everyone. Bill Van Leeuwen. I've been here 23 years.
And how long have you been on the Board of Adjustments?
I have no idea.
Yeah.
We started.
Yeah, I don't know, 8 years, 10 years? I'm not sure.
Yeah.
Really, it's very good. And I live in Eagle Canyon and, I'm excited to see you guys again.
Yeah.
I'm Jim Kerr. I've been in town for 12 years and been on board adjustments for about 1 year, just one meeting.
Yeah. I think 1.5 years, because the last one was like fall of 2022. Yeah.
I'm Greg.
Yeah.
I'm Greg Hooker. Let's see. Been in town, well, in the area anyway, for about 23 years too. 2002. So I think that's 22, 23 years. And worked at the university. Board of Adjustments. About 8 years too, I think. With Connie, I think it was that round of, she was out looking for people.
Yeah.
Connie Sullivan.
Connie Sullivan.
I'm Connie Eister. I've been lived in town since 2001. And I've been on the Board of Adjustments since before I was pregnant with my child.
Oh my
So he's almost 15, so it's probably about 16 years ago. Yeah. Hi, Lee.
Hi, I'm Lee Williams. I've been in town for 8 years now. Feels like half that, and I probably learned as much as I would if it were half of that 2 years. I spend most of my time doing small scale real estate development, helping out with fire and just doing little things along the way. Pitching in.
Joe Soma, and I've been in town for 14 years. And
You've been on a long time.
a long time, it's probably been 11
Yeah.
or so years.
Yeah, and Joe is on the team that won the line softball championship.
Wow.
All right.
Didn't touch that.
See what happens. in
This
2020.
last year, lost the year before.
Yeah, who did you lose to the year before, John? I've sort of forgotten. Was it the Hooligans?
Mhm.
Yeah.
Oh, yep,
Awesome.
and Dan did not let us forget.
All right, okay, now we've done our introductions. Erin, you wanna, cause you're kind of new to our group.
Aaron Kaplan, director of whatever you want me to be director of at the moment, or utilities and handling some of the planning at the moment.
And I will just say for Lee and maybe a little bit for Jim, in the past, the Board of Adjustments has had a town planner who makes recommendations on the various applications that we receive. And so Erin, are you doing that now? Are we?
I would say yes, if it was needed. On this case, I don't know, I was speaking with the attorney Dittman, and it sounded like this was one where we were just making sure that they met all of the requirements there. So I didn't know if it was appropriate to make the staff recommendation one way or the other, that it was up to the board. I guess it was getting a better understanding, but that the Board of Adjustments should really be the one stating if it meets all of the criteria to have the variance allowed.
Yeah, I'm sorry, I should have phrased my question. Or is it part of your job description? Are you the person who's going to be working with us, or is there?
If we hire a new town planner, they may do that, or the assistant planner, let's say Cassidy, if she was to really continue on as the planning, she may step into it. For now, it is me.
Okay, terrific.
But to your point, typically someone does make a suggestion.
Yeah.
Right, a point of view.
In the past they have, yeah. And then Dolores, do you want to introduce yourself and your role?
Yeah,
and-
hi Dolores, good to see all of you guys. Dolores Vasquez, I'm the town clerk. I've been with the town now almost 20 years in various capacities. I know I say that too, Lee. I'm wise when you're having fun, but it's good to see you guys, and we don't meet, like they say, just, you know, variances come up here and there. Sometimes it seems like we get a whole bunch and we see each other a lot, and then we don't see each other for a couple of years, so it's good to see everybody again.
Okay, great. And then Brandon, do you want to introduce yourself and tell us a little bit about what we should be doing and how we should be doing it?
Yeah, of course. So can you guys hear me okay first?
That's-
Excellent. So my name is Brandon Dittman. I'm attorney of the law firm that's now called Wilson Williams Fellman Dittman. I've been a town attorney. I was trying to count off my head. I think it's almost 8 years now with the Town Alliance. And so I don't get the opportunity to see the Board of Adjustments very often, but have helped out here and there. And so in talking with town staff, we thought it was a good idea to do kind of a refresher on the Board of Adjustments, what the Board of Adjustments is, what some of the rules are for procedure, just kind of given the infrequency in which it meets in Lyons. And I have a PowerPoint presentation when I pull up, we can run through, but just know that if you have questions at any time, this is not a formal thing, just feel free to interrupt me and we can answer those questions. So hopefully the screen share will work. Can you guys see that? Okay.
It's a little small, Brandon.
That's as big as I can make it, I think. Maybe Dolores, if you could pull it up on your computer, but maybe that might be better.
I think there's a way to focus.
There you go,
up.
that's better.
Yeah.
Brandon, did you freeze? We
Yeah.
lost him.
You dropped off, Brandon. Now you're
And you're
muted.
Sorry about that. Yeah, Zoom crashed again on me right when you said it looked better. I don't know why it's been doing this with PowerPoint specifically. Dolores, could you share it on your screen by chance?
I have to be host to share. Did you send me the PowerPoint?
Yeah, I sent it earlier today.
Oh, yeah, you did.
We log on to that meeting and I could just look at it here.
Oh, let's see if this will work. Well, it's not letting me do it either, Brandon. There we go. Okay, I've got it up. You tell me when to change the page.
Okay, yeah, we can go ahead and move to the first page. If you
Okay.
want.
We're on
Okay,
page-
thank you. So my first slide is just a really kind of basic slide. What is the Board of Adjustments? Given that a few of you or at least are new to the Board of Adjustments, and where I always recommend with any board and commission when we're trying to figure out, what is my role, is we have to look to like what is the authorizing statute or ordinance in town code that defines, really the rules of the road for that particular board or commission. And so you don't need to memorize this, but I just want to have it as a reference always, what does state statute say first? And so in state statute in Title 31, which contains most of the municipal regulations, it lays out what a Board of Adjustments is. And it says that each governing body shall have appoint a Board of Adjustments consisting of 5 members, unless changed by ordinance. So in Lyons, we've changed that obviously. And the Board of Adjustment shall hear and decide appeals of the enforcement of any zoning ordinance. So that's one thing the Board of Adjustments does. Shall also hear and decide all matters referred to it, or which will be required to pass under ordinance. So we can change also the scope of the Board of Adjustments via ordinance. So in Lyons, we've done that as well. In a very kind of unique situation for the Board of Adjustments specifically, it does require a very specific number of members to pass a variance or any kind of a determination of the Board of Adjustments. It requires at least 4, to pass a vote. That is not the same for any other board or commission. Usually it's just whatever the majority of the quorum is, with some very limited circumstances for the Board of Trustees. That is enough to pass whatever it is that Board of Commission is working on. But for the Board of Adjustments, it's very specific under state law that it has to be at least 4 members, regardless of the quorum as present, to do really anything that's before it. And then kind of the last part I have here is that, one of the things that state statute lays out is that you can do variances and ordinances. So that's, one of the things we're going to do tonight is look at variances and ordinances. And the Lyons Municipal Code, we have expanded upon and kind of changed, as I've already highlighted in some ways, what the Board of Adjustments does. And it's in chapter 2 of the code, which contains all the administration and all the boards and commissions. You can look at all of them about membership and what they do. But what we do is we say we've created a Board of Adjustments that shall act as an advisory committee of the Board of Trustees and exercise all the powers granted to it under state statute. We just read through. We have 7 members in Lyons for Board of Adjustments. Again, not necessary. It could be 5. I've been in many jurisdictions which have just 5. Does make it really hard to do anything because again, you need 4. So if you have 5, you have to get all but 1 vote to pass a variance. And in Lyons, we do require members of the Board of Adjustments to live within the town for at least 1 year. And we've expanded upon the responsibilities of the Board of Adjustments, including, what's under state statute, hearing appeals made a decision of administrative official. So if the planner makes a decision, the building official makes a decision, the administrator makes a decision, all of those kind of determinations, so long as it is a determination, can be challenged at the Board of Adjustments. Hear and decide all requests for variances from the bulk requirements of the code. So pretty much any code requirement, not just zoning, you need to adjust, a variance from. The Board of Adjustments can hear that. Recommend, or some very few that require review from the Board of Trustees. So in the cases where it goes to the Board of Trustees, you can also recommend variances to the Board of Trustees. And then the last one we don't really use as much, but administrative review of decisions of the town inspection division, including but not limited to all matters relating to building construction. So that one's usually does not come up as much, but that's one of the other responsibilities laid out under the Lyons Municipal Code. So we can move to the next one, Dolores.
Gotcha.
And so, what does all that mean kind of in a plain language way of looking at it? Well, the Board of Adjustments is a quasi-judicial board that reviews zoning and building code requests and appeals. They can also grant variances and special exceptions to the Lyons Municipal Code. So that's what they do. When we break that down, appeals of decisions, variances, which are just exceptions to requirements, and that the Board of Adjustments is a quasi-judicial body. And that's going to get really important as we kind of go through this presentation, what that means. But in the simplest way of thinking about it, it's like you're acting like a court, which means you have special rules attached to your decisions in order to ensure fairness. And so we'll move on to the next slide and we'll kind of talk about what that means. Okay, so quasi-judicial proceedings generally. And then what we do is we kind of split in terms of how a board or a commission acts into 2 different categories. Quasi-judicial, which is the world that the Board of Adjustments live in, and then legislative. And what you need to know about quasi-judicial, first you can break it down just from the Latin, that's part of it. Quasi means like or similar, and so you're like a judicial body, right? So like a court. What do courts do? They narrowly apply the law to a situation. So you don't create any policy, that's what the board does. You're applying the policy. So applying existing law, which is the Lyons Municipal Code in this case, to a very specific set of facts. Specific land use approvals, licensing hearings, nuisance abatements, licensing renewals and revocations. All those things, again, you're not creating policy, we're deciding something as regards to the rights of an individual or a business entity. Therefore, it is a quasi-judicial thing. It is like you're applying facts to law, and vice versa, not creating law. In contrast, we have legislative actions that can be taken by other boards and commissions, primarily the Board of Trustees. That's when we make broad application of new policy that is basically distilled into law. In the case of Lyons, that's an ordinance that amends the Lyons Municipal Code. It also includes resolutions and proclamations to a lesser extent, but these are, issues of broad applicability. So it applies not just to specific facts of one person, but to the town at large. And so we think about like an ADU ordinance that applies to every property owner in town. Nuisance applies to really anybody in town. Building and zoning, land use codes, all broadly applicable to everyone doing business or living in the town. Therefore, is a legislative act. And so again, where we take a step back and think about, what's a legislative action. Think of the General Assembly of Colorado or Congress, creating law. And as you think about it, a court versus Congress, for example, courts have lots of rules about how they conduct their business in order to ensure fairness. And I think as we all realize, there's very little rules in Congress, right? They don't have, nearly as many rules about conflicts of interest, about how their procedures operate. There are some internal, kind of rules, but they can be broken fairly easily. Versus a court has very strict rules and consequences for judges when they break those rules. Okay, so we'll move on to the next one. Okay, so now that we know, generally what a quasi-judicial body is versus a legislative one, as I mentioned, there are more rules for quasi-judicial proceedings and quasi-judicial, participants, which are in your case, members of the Board of Adjustments. The key thing that to remember about quasi-judicial proceedings is that impartiality is the most important thing. In order to ensure fairness, the members of the Board of Adjustments must be impartial in making their decisions. And there's a couple different kind of things that go into considering what is impartial. And so the first one, another fancy kind of Latin word, ex parte communications. And ex parte is Latin for outside. And what we're talking about is communications that happen outside of the body, outside of the hearing that's being set up to hear a particular set of facts. And so when there's communication to a member of the quasi-judicial body that is not addressed to all members of the quasi-judicial body, which occurs outside the presence of the applicant and all parties to the case, including people who may oppose a variance being granted, that is an ex parte communication, which is prohibited by the rules of quasi-judicial procedure. And so an example of this, a neighbor comes up to you at Oscar Blues over a beer and says, I'd really like to talk to you about this variance you're considering next week on this subdivision or on this ADU. That is a conversation that is happening outside of the hearing, and therefore it is an ex parte communication and potentially prohibited from being considered as part of the proceeding. And what we're really concerned about here in ex parte communications is really, fairness. That it's not fair that one member of the quasi-judicial body knows information that nobody else knows. The other judges may not know, that the applicant may not know, that opponents to whatever is being considered may not know. And the idea is that everyone should be working up the same set of facts. And so if we're doing things or hearing things outside of the hearing, there's different levels of information then, and a fair decision may not be able to be reached. So that's one of the components of impartiality, is no ex parte communications. The second one is a prejudgment or bias. And so I think we kind of generally know what that means. Prejudgment is when you consider something before you heard all the facts. And so an example of this, which has happened, is that someone gives a speech and signs a petition saying, I will never vote for this application ever, and they've never even heard the evidence as part of a hearing. And so that would be an example of prejudgment. Bias is when you just can't possibly consider an application impartially, that you have some sort of feelings, emotions, way of thinking that makes it incapable for you to consider fairly an application. So A common example of that is, someone's friend or close friend or relative, is the applicant, and there's just no way you can put those feelings aside for that person and rule against them. And in that case, you have a bias problem that you can't consider the application impartially because of your preconceived feelings and emotions towards the applicant. It can also show up in a less common way as you really dislike the applicant, that you guys have a personal history, that you just cannot, bring it upon yourself to ever give them anything, given your kind of animus towards them. That's another example of bias that kind of works the other way, where it's not, favorability, but it's, really unfavorability that's kind of baked into your decision making. And in both those cases, there is no impartiality, there is no fairness, and we have a problem. The last one, which is the one we kind of think about the most, impartiality for fairness, is a conflict of interest. And these are, in the most extreme cases, are financial. And the case that, as we'll see later, really can lead to the most sorts of personal liability for yourself is that when you have a financial interest in the decision. So the most clearest example of that is, your spouse is the applicant. If the application is granted, that you're going to be able to make more money from the ADU in your backyard, or your business is going to be able to expand, that you have a direct kind of financial stake in the decision being made. And so that's a very clear problem for impartiality, also a very serious one in terms of legal liability. But that's kind of the third category of potential conflicts. So we can move on to the next one.
Okay.
And so, these things happen, right? Conflicts happen usually by no fault of anybody. They just occur as part of life, and particularly in small towns where people tend to know each other and, interests may be kind of commingled from time to time. And so accidents happen. It's not the end of the world that these conflicts or these impartiality issues arise. And so the question at that point in time becomes, how do you fix it? Or in the legal terminology, how do you cure the problem? And so, the best medicine for all of these things is really disclosure for the most case. And what you need to do to figure out whether you have a problem is ask yourself, was my ability to decide this case fairly and impartially being affected by whatever this is, right? Because usually when there is conflicts, there may not be, clear whether it's a real conflict or not. And so if, there's clearly an impact on your ability to decide the case, that's a conflict that needs to be cured. Or if there is an appearance of conflict, even if none exists. And so if everybody thinks you're best friends with John Doe, who has an application, and people are saying, well, he'll never consider this fairly because they're best friends, and it's appropriate then to correct that, even if there actually is no conflict of interest there. And so there's really, two ways of curing these issues. The one that, we usually rely upon is disclosure, which says, that, John Doe is my friend, that we've known each other for a long time, but I am able to clearly and impartially consider the decision before me, and our friendship has no impact on my ability to fairly consider this application. And so that would be an example of disclosure that would, for the most part, cure any potential appearance or actual conflict of interest in the case where there may be a perception of bias. Same with ex parte communications. A lot of times what happens is an ex parte communication happens and you don't even know it was an ex parte communication until you're way into it. That in the conversation's happening, someone's talking about someone, and then at some point you realize, oh, they're talking about this application that's going to be coming for the Board of Adjustments. At that point, time out, can't talk about this anymore, but you still have a duty to disclose that happened, and that ex parte communication is not going to influence your decision. So what you do is, and we'll talk about when you do this, but you do a disclosure on the record saying that I was at Oscar Blues and I was talking to John Doe, and before I even knew it, he was talking about an application, and I have disregarded all the information that he told me, and it's not going to, impact my ability to hear this case, and I will only consider the facts that are presented to me during the hearing. So that's an example of a disclosure for an ex parte communication issue. The ones that are really important for anyone, whether it be the Board of Trustees, the Board of Adjustments, or anyone else doing a quasi judicial proceeding, to one, identify, and two, recuse yourself is financial conflicts. And so if you have a direct pecuniary interest in the outcome of whatever it is you're deciding, that not only requires disclosure, but also recusal. And recusal doesn't just means that, you don't take a vote. It means you take no part in the proceeding on that item. It basically means you leave the room. And the reason why that's important is several. And the most important one, I think, we'll get more into what the consequences are, but the most important one is you could face potentially personal legal consequences for being involved in a decision that includes your financial interests, and that's either through the state ethics board, which has the powers to enforce fines for that type of behavior. Their corruption, public corruption, is a charge that can be charged federally and at the state level as a crime. And the town's ability to protect you under governmental immunity does not apply where you're working outside the bounds of your authority, which includes situations where you have financial interest in the decision. So big consequences for that one. Luckily, they don't pop up very often, and usually they're fairly easy to identify. But I cannot stress enough, if you have a financial conflict, that is something that requires recusal, not just disclosure. And the important thing to remember here is that when in doubt, you can always ask. You can ask the planner or Aaron in this interim period. They can get you in touch with me. We can talk about it, about whether there's a conflict there. But in most cases, a conflict can be resolved fairly easily, usually through disclosure. But even in cases where there is a more serious conflict, just recusing yourself and doing that before you decide anything will protect both yourself and the town from any sort of potential consequences of that. So next slide, Dolores, please.
Yep.
Okay, so we're gonna get into now some of the importance of maintaining all this, including some of the consequences if you don't. And so the important thing, this generally, and to maintain the quasi-judicial procedures, is that all your decisions need to be based on the record and rational, right? And so what does that mean? It means you can't, act beyond the code, because acting beyond the code is irrational. It's not something that you're allowed to consider. You can only apply the facts that are in the record to the standards in the code. So what does that mean? It means you can only consider evidence that occurred during the hearing, things that were included in the staff package, things that were said by the applicant, questions that were answered by staff, things that were said by members of the audience who opposed or supported the application. If it's outside, again, ex parte to the hearing, you can't consider it. It's beyond the record, and you can't consider it. Included in kind of this bucket of irrational decision making is things like personal opinions. I have a strong personal opinion that I will never vote to approve an ADU. That's not rational. It is not based on the standards that are in the code. Emotions as well, as I overcome with emotion. I cannot vote yes or no on this because of that emotional kind of impact. Again, that's not irrational. That's not rational. It's not based on the code. It's not based on the facts, and so we're not allowed to consider it. All the decisions we make have to have fairness, and fairness kind of comes in two different flavors, if you will, under the 14th Amendment of the Constitution. One being procedural due process, and second being substantive due process. Procedural is fairly self-explanatory. It's just we have to follow the process, right? And we follow the process, so it ensures fairness, that there's predictability of what's going to happen for the applicant, for staff, for the people who support or oppose the application that come and present their opinions. Everyone is entitled to a process which is predictable and which is fair. And so we have to follow the process which is laid out in the code and under Colorado law, pretty much to the T. The second part of this is, substantive due process, which is like, was it actually fair? Was what we did, and fair? And this plays into those kind of conflict issues a lot. This includes everyone gets the opportunity to be heard in accordance with the process. You can't say, no, I've heard enough from, the applicant. And this, I was outside of the procedures. We're just not gonna let them talk anymore. Now, if they've gone over their time frame and is a established process ahead of time, that's okay. But it just preventing people from, letting their voice be heard in accordance with the process is a violation of their substantive due process rights. The other important part of this is, again, making sure that everything that happens is inside the confines of the hearing. There can't be secret evidence, secret decision making. Everyone has to have basically the same evidence in front of them and the same opportunity to be part of the decision making process. So no secret meetings, no ex parte communications, no prejudgment by getting together with your Board of Justice members ahead of time and saying, let's figure this out before it even comes before the board. All those things are a substantive due process violation. And then finally, this kind of, all this kind of plays into this, but the decision has to be impartial. If the decision is not impartial, then it's not fair. Doesn't follow substantive due process, and we have violated someone's constitutional rights to a fair process. These decisions that the Board of Justice makes are appealable. And so in most cases, that means appealable to a district court and in Boulder County. And what they're looking at is, like, was this decision made within the authority of the Board of Adjustments? Did it have procedural and substantive due process? They will look at the record in order to determine whether or not that all occurred. And so again, if there's a lot of evidence being brought forth by an applicant who was aggrieved or a neighbor who was aggrieved by a decision, and say, hey, look, they said they, collected all their evidence in the record, but here's all the text messages I have between, the BOA and the applicant, or Facebook communications between the BOA and an applicant that, definitively proves there was ex parte communications and they didn't disclose it on the record. My rights have been affected, and there's a number of different outcomes that can happen from that. The most typical one is that the decision is overturned, or it's referred back to be basically done over. And that's, very expensive for the town to go through that process. In more extreme cases where you've taken away someone's property rights, there may also be, financial penalties for the town, or, things that we have to do in response to a decision that was done improperly. Or we have, taken away someone's constitutional rights, which you could also have financial penalties associated with it. And so that's never a good thing. And then in extraordinary cases, I've already kind of mentioned, you could have personal legal liability, which, we never want to happen. It's extremely rare. But again, if you had a financial stake in the outcome and you didn't recuse yourself, you could very well have personal legal liability by participating in that decision. And so, these procedures that are in place, they're established under the code and under state law, are really important for protecting the town and for protecting you as an appointed official from liability. And so when we follow the procedures by the book, there's a lot less risk to everyone. And we make sure that we have a fair process, and then everyone feels like they were at least heard, even if they didn't get the decision that they wanted. And so that is the quasi-judicial kind of parameters in general. Before I move on to kind of process within the confines of a hearing, are there any questions on what the Board of Adjustments is, or how quasi-judicial procedures work?
No questions, Brandon.
All right, hearing none, we'll move on to the next little bit, which is the next slide, and which is really just the order of the hearing. And so I know it's been a long time since you guys have met, and so there is a very specific hearing kind of format we follow for quasi-judicial procedures. This is one to give a refresher on that. The first part, which we usually even put on these lists, but I thought might be a good idea to do, is that I may give you some legal preliminaries before we even start, right? That I may say, here's the process for this particular thing we're doing here tonight. So basically what I'm doing now, we may do prior before we even begin the agenda item, right? It's the very first thing. I may give some advice on how the process is going to work. The next thing that should happen once we open this item up for a public hearing is that the disclosures and recusals, if they are necessary, should happen at that point. And so before we even get into the evidence, before there's a staff presentation, before the first word is said about what it is we're doing, other than what the name of the agenda item is, we should be doing all the mandatory recusals and disclosures. And so hopefully, you and I have talked about this, or you and the staff liaison have talked about this beforehand. So we have some knowledge that it should be happening. And if you forget, we'll remind you. But at this very early stage, it's important to do disclosures and recusals. The disclosures, again, just stating on the record that, there's an appearance of impropriety here, but there's actually not, and I'm able to fairly and impartially decide this application before me. I mean, those are the magic words that despite this appearance or despite this thing that happened, I am still able to fairly and impartially decide the application before me. Usually does the trick in terms of disclosures, and so long as it's true, right? Yeah, I don't want you, lying on the record. It should be true what you're saying, but so long as it's true that you can impartially and fairly decide an application, just putting those kind of words into the record usually will insulate you and the town from liability in almost all cases. Recusals, again, there's confusion on this. Recusal versus abstention usually comes up as an issue, but if you have a financial conflict and you need to recuse yourself, or you feel like you possibly cannot decide something fairly, recusal means you say at the beginning that I have a financial conflict because I'm part owner of this business is seeking this application, and I will not be participating in this proceeding. And then you get up and leave the room. You're not part of this. You don't hear the evidence. You're not in the audience. You're just physically not present. So as your presence would not create any sort of question as to whether the decision was influenced by you just being there. Maybe certain people are afraid of you, or people like you, and so they don't want to disappoint you in front of you. And so you have to physically remove yourself from the room. The thing sometimes what happens, or what people think might happen, is you get to the very end, you're like, well, I'm just not going to vote because I have a conflict. I'm just going to abstain from voting. That is not acceptable. It's, of course, that's better. You didn't realize until the end that you had a conflict. It's better to abstain than to not. But what you should be doing is, if you know ahead of time that you have a conflict, is that you should be recusing yourself at the beginning and not even being present for the presentation of the evidence. So something to keep in mind, every now and then that comes up as an issue. So once we've gotten through all the preliminaries, I've given you the advice on what we're doing, all the disclosures and recusals which needed to happened. Then we'll get into the meat of the public hearing. And where we start is the staff presentation, where staff, whether it be the planner, Aaron in this interim period, in very rare cases it may be me, gives a presentation on what it is we're doing. And there may be a recommendation attached to that. There may not be a recommendation attached to that if staff doesn't have a strong opinion one way or the other. And we give that presentation. When that presentation has concluded, that is the opportunity for questions for staff. That is not the opportunity for discussion. That is only after we've heard all the evidence. So you can't say, as part of your staff questions, like, well, not hearing that, I think X. You really should not be doing that. You should not be making any determinations until we've gotten to the end of the public hearing. So once staff has given their presentation, you got all your questions answered by staff. We then move on to the applicant. The applicant gives their presentation, and then we're given the opportunity for the same thing, to ask questions of the applicant on their presentation. Again, no deliberations, no discussion, no making decisions, just questions and presentations during this stage. We then move on to public comment, where the audience is given the opportunity to present, their position in either 3 or 4 minutes, depending on what it is. And we listen to all that evidence. We do not respond to the audience directly. As part of our deliberations, we may reference, the audience. We don't respond. We just take in evidence from the audience. The next portion is the applicant rebuttal. This is optional. The applicant is not required to give a rebuttal, but if they want to give a rebuttal in response to the public comment, they have the opportunity. And then, you can ask questions on that rebuttal after the rebuttal is given. I find, at least in Lions, there hasn't been a whole lot of rebuttals, but, from time to time, something is said by the audience, and the applicant is given the opportunity to respond to that. Once we're finished with the rebuttal and any sort of questions that happen during the rebuttal, we then close the public hearing. And that what that means, there's no new evidence being presented. That basically everything we're considering as part of this application has already been collected, which means that once this happens, the only questions we should be asking are clarifying questions of things that have already happened. If we never talked about the setback of this property, wasn't in any materials, it wasn't a question, it wasn't an audience thing, an audience point was raised, you then can't say, well, I know this wasn't part of what we talked about, but I really want to hear more about the setbacks. I mean, it's not part of the record. It's not relevant for discussion once the public hearing has been closed. And so it's really important that if you have questions on things, that the extent you have them, you ask them during the public hearing portion of the hearing. Okay, so we'll assume that we did everything right. We had the rebuttal, we had our questions, everything was answered, and we're going to close the public hearing. We then kick it off with a motion and a second to put the matter before the Board of Adjustments for deliberations. Sometimes people get really hung up on the ideas like, well, if I move to do something, that means I support it, and that is not the case. You can move to say I move to approve the variance for the purpose of discussion, and then you get a second to open up the discussion. You don't, just because you motion or second something does not mean you necessarily just support it. The vote is separate. And so I've seen in my many years of practice, all sorts of people get kind of, like, well, I did the motion, it means I have to vote for it. No, that does not mean you have to vote for it. It just means that you put it before the body for deliberation. And so once we have a motion and a second, we can then deliberate. You can then say what your opinion is. You can then, ask clarifying questions of staff. We can work through, whatever it is that's before us, including potential conditions, if that's a relevant thing we can do as part of those deliberations. So once we've decided on, all this deliberation has ended, we've had all our clarifying questions answered, there's no more back and forth between the Board of Adjustments. There are no more amendments or conditions that we are going to amend our motion to include. We will then do the vote. And once the vote happens, that is the end. There is no discussion after the vote. The record is closed. The item is decided. There is nothing further after that. In very rare cases, and this shouldn't be the case in the Board of Adjustments, I don't think ever, what we may do is we may vote, and you may ask the city attorney or the town attorney in the Lyons case to say, we would like you to write a written decision memorializing our decision for approval at the next meeting. And so usually those are for highly contentious legal decisions where there is a high likelihood of appeal. We may say in those cases that we'd like a written decision written up. So that way the court can not only look at what was said, during the hearing, but also the written decision, which memorializes what was said. And so probably not going to happen ever for you guys, but if there is a highly contentious item that ever comes before the Board of Adjustments, that may be an option. So that is the rundown of the process. And again, at least for tonight, I'll be here. We can work on it. For future meetings where I may not be here, that is the process we should be following for every single application that's before the Board of Adjustments. Any questions on process?
Brandon.
Okay, well, that is the end of my presentation. If this is distributed, my contact information is on there. I know the town does typically like you to go through Victoria, through your staff liaison before you contact me directly. But if there's a personal ethics issue, I represent the town, not any individual. And so I am available to work through that. So that is my presentation. Again, I'll send this out to everybody. There's a couple of corrections I made during this, for your future reference. But hopefully that should give you a pretty good idea of, what we do, how we do it, and, what some of the issues that may come up are.
Any questions for Brandon? Okay, thanks. And Brandon, you're gonna hang out for the rest, or you're heading, or you're? Okay.
Yeah, I'm going to hang out for the rest of the meeting. So I'll be here to help if anything comes up.
Great. Okay, So then, first thing on our agenda is can we go ahead and get started?
Well, I think we need to call the meeting to order first. Because before we were doing a workshop, so we'll have to do a roll call to make sure we have a quorum so we can actually take action.
Yeah, I guess we were just about to do that, the roll call and the pledge of allegiance, Brandon. Dolores, do I do it or you do it? I can't remember.
Nope, I'll do it. You'll just, I'm calling the Thursday
Call to order.
call to order. Okay, roll call. Chair Eister,
Present.
Member Van Leeuwen,
Present.
Member Kerr,
Present.
Member Euchre,
Present.
and Member Soma.
Present.
And then we'll be swearing in. the new member. Yeah.
Okay, now we do the pledge of allegiance. The pledge of allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, we have a motion to approve the agenda. Do we need a motion to approve the agenda?
I believe so.
A second? Second. All in favor of approving the agenda?
Aye.
Okay. Now we have a. Go
We have a
ahead.
voting system too. There's buttons there on the side, down here below you.
Oh,
It's
oh, is it on?
been a while. So they'll vote and then you'll flip
Try
it,
this.
chair. There you go.
Yeah.
And
There you go.
All right. That's,
and the motion passes unanimously, I believe.
that's fancy. Okay, since we have a new member, Dolores, are you gonna do the swearing in?
Yep. Let me find out. Yep, Lee, if you'll stand and raise your right hand. Do you want this to follow with? Yep. Repeat after me. I, Lee Williams,
I, Lee Williams,
do swear that I will support the Constitution of the United States,
do swear that I will support the Constitution of the United States,
the Constitution of the State of Colorado,
the Constitution of the State of Colorado,
and the Town of Lyons Municipal Code,
and the Town of Lyons Municipal Code,
and faithfully perform the duties of the Office of Board of Adjustments of the Town of Lyons, upon which I'm about to enter.
and faithfully perform the duties of the Office of Board of Adjustments of the Town of Lyons, upon which I am about to enter.
Thank you very much. Congratulations. Thank you. We're glad to have you, Lee.
Okay, the next item on our agenda, which we'll run through very quickly, is, we have, in my memory, not really ever voted on chair and vice chair, or maybe we had, but it was a long time ago. And I went to a general board training for the town, and apparently we're supposed to be doing that. And so I thought at the beginning we would do that. And I've been serving as chair for some time, and I don't even know how that happened. But I'm happy to keep doing it, or if somebody else wants to do it, I'm also happy for someone else to do it. And I don't know if we've ever had a vice chair, like official, but it would be good to have that in case, I can't be at one of the meetings and somebody wants to step up. I know, I'm looking at Joe, like, I know you're.
I did that once or twice.
Yeah.
Way back.
Yeah. Yeah. So let's start with that. So does somebody want to nominate someone to be chair?
I'd like to nominate Connie to be chair.
I'm happy to do it.
And I'd like to nominate Joe to be vice chair.
I would like to nominate Joe to be vice chair.
There's one issue with that.
I know. Or you don't want to stick around?
I'm pretty sure that,
All right, I nominate Bill to be vice chair. Okay. Should we vote on those separately, or are there any other applicants we can vote on all at once? Okay, so, all in favor of me continue to serve as chair and Bill as vice chair?
And that motion passes unanimously.
Okay, so the next is that we need to approve the minutes from our last meeting, which was December 2nd, 2022,
Yeah, that's right.
2 years ago.
I make a motion to approve the meeting notes and I read them.
Terrific. A second,
I'll second
all in favor?
And that motion, Lee, I don't see
it.
you.
You got
I'll
it.
abstain,
You
not
abstained
having
because you were not at
attended
that meeting. Okay, so the motion passes, 4-1.
Okay. All right. Thank you to everyone here for their patience and letting us go through those things. All right. The first application on our agenda is the various applications submitted by Daniel Lee and Tracy Sobel for a lot subdivision variance for the property located at 217 High Street. The item is scheduled for a public hearing for the board. Purpose of the Board of Adjustments is to consider variance requests and appeals of administrative decisions. In considering an application before it, the board must hold a public hearing and will follow certain procedures in order to conduct a hearing that's fair, impartial, and orderly. As a general rule, each individual speaker will be given 5 minutes to speak, and the applicant's primary representative will have up to 10 minutes to present the application. Subsequent speakers representing the applicant may speak for up to 5 minutes per speaker. The board may ask questions of the applicant, staff, or any speaker at any time. If there are members of the public present to comment on the application, the board will generally allow each speaker up to 5 minutes to address the board. The board discourages repetitive testimony. The concurring vote of 4 members of the board is necessary to reverse or modify any decision or determination of the town to approve a variance application. And now open the public hearings on variance request for 217 High Street. First, are there any disclosures or recusals from members of the board as related to this applicant?
I have a question of whether or not I need to disclose something.
Okay,
I did send an email to town staff, a question I had on the application, and I'm not sure if that's something I need to disclose or not.
So
well,
typically not. If it's a question of town staff, you just have a question about the application. That's not considered an ex parte communication. I mean, I assume that we will also bring that up during our discussion, so it's in the record, but those communication, like you have a question about the application, that's not, you know, an issue that needs to be disclosed. You can always if you want to, but it's not necessary.
Okay, well, I'll bring it up if town staff doesn't.
any other disclosures or recusals? Okay, great. Now we'll hear from Director Aaron Kaplan, who's going to give us an overview of the case.
I did want to check first, though, there was the legal proceedings aspect. Is this something where you or I, Attorney Dittman, should discuss that there was the previous ordinance, change of the board, a new ordinance, or is that not? And then a second.
I think we can do that as part of your presentation, Aaron. I mean, what I have for legal proceedings, like we already kind of covered. So usually that's just me explaining the process. But I think if you want to give the history, I think it's more than relevant for the staff presentation.
And the same would go then for that, this, to explain that this is to meet the requirements for the variance to allow it to go forward for subdivision, that this is not the subdivision process itself. Right, so for the staff presentation, to start with, there was an ordinance passed a year and a half ago, I'm not sure, a couple planners ago, that we were looking at allowing lots that were slightly under the 7,000 square feet, that were some of the original lots from the original town plat that lost some of their square footage for different reasons, an alley going in. That ordinance was passed, and staff and the applicant thought it was the ability to move forward. It was determined that that language was not appropriate or not sufficient to move forward with just allowing the subdivision to go forward as planned. So staff had to come back with a second ordinance to determine how to allow this subdivision that would be under 7,000 square foot per lot, which is a requirement for the R1 subdivision. And at that time, the Board of Trustees had changed, and we had a new Board of Trustees, and they proposed slightly different method of how to do these particular types of subdivisions. And they requested that they go through the variance process to show that they do not meet the 7,000 square feet, but they meet the additional to show that even though they don't meet the 7,000 square feet, they meet the additional requirements placed in there to approve the variance. You think that's correct, Attorney Dittman? And then just to explain and make sure you all understand and are aware that this is going through the process to see if this application meets the requirements for the variance, to allow it to then proceed with the subdivision process. So the subdivision requirements are not part of this particular decision-making. It's the specific variance requirements that were listed in ordinance. I think it's 1171 that was included in the packet. It is not yet codified online, so that's why we did include that ordinance. And so I think it's appropriate, probably more appropriate to start with the actual application, and then I can go through how it meets those requirements that are in the variance. So we have an application for 217 High Street, which was a double lot that was platted. It was 14,000 square feet. It lost a portion of that square footage when an alley was put in behind it. And so the applicant had come forward, as we mentioned, it's been a year, 2 years, looking at this process, and had worked through, thinking they were ready to move forward with the subdivision, has now come back to present this application to go through the new process for the variance. And the variance requirements that were put into the code are that the Board of Adjustments may approve a variance for a minimum lot area required by section 16(3)-150, which I guess I don't know specifically what that one was. It should be that the R1 variance, again, is 7,000 square feet. So this variance is for the minimum lot size for 1929 lots, which this lot is one of the original 1929 lots. And the Board of Adjustments shall find that all the following criteria have been satisfied. The lot to be subdivided is legally described standard lot or a double lot of the Town of Lyons platted blocks as recorded on March 20th, 29. It is. No such lot shall be subdivided more than once. At this point, this is the first subdivision, so this is only once. No such lot shall be subdivided into more than 2 lots, not being subdivided into more than 2 lots. No resulting lot of a subdivision of a lot recorded on March 20th, 1929 shall be less than 6,000 square feet. Both of the lots do meet the 6,000 square feet requirement. The Board of Adjustment should also consider the following: that the variance, if granted, will not adversely affect the proposed development or use of adjacent property or the neighborhood. That the variance, if granted, will not change the character of the zoning district in which the property is located. That the variance, if granted, is in keeping with the intent of this code, and that the variance, if granted, will not adversely affect the health, safety, and welfare of the citizens of the town. And that was my staff report.
Any questions from the board for Aaron?
Should I bring up my question?
Sure.
You can, sure.
The question I asked Aaron was that there is a concrete block garage on there with the proposed property line going down the middle of it. I just wanted to clarify that that's not an issue at this stage of the process.
Right, and Attorney Dittman, it may be the, for you, but my understanding was that would come out during the actual subdivision application, if that was a concern or not for the subdivision, but was not one of the requirements listed for this variant.
Yeah, I think that's right.
And I suppose the applicant could talk to that in their presentation if they wanted to, if there were, or wait till the subdivision.
Aaron, does the town have any opinion on or whether or not these requirements have been met? Whether it will adversely affect the proposed development or use of the property? Or if it will change the character? Or if it's in keeping it within intent of the code?
So it did appear to meet all of those. Staff did feel that this was being proposed to go back to what could have been a separate lot with a separate R1 structure built on it. Now with the new amendments to the code allowing ADUs, that would not be affected specifically by the variance. A property, again, if it had been 2 lots to begin with, would still have that and would meet the character of the neighborhood. If it would change, keeping with the intent of the code, yes, it was keeping with the intent of the code, again, that we've gone through a couple of iterations with boards of trustees desiring to allow these lots that, but for the alley going in, would have been allowed by the process of a subdivision.
Aaron, I don't know if you can answer this question, but it's sort of an odd procedural step for us, because normally when we're making determinations that apply similar criteria, for variances, we know what's being proposed. You know, we wanna put a porch on, or we wanna renovate something, or, you know, we know what's being done. So when somebody asks us if the proposal is gonna change the development or the, you know, property, we kind of know what we're dealing with. Here, we're just being asked, can it be subdivided without really addressing what's gonna happen once this proposed subdivision occurs? Is that correct?
Yes, I would agree with that.
Okay.
And it could be a procedural, but that would be something that could be asked of the applicant. Would you agree, Attorney Dittman?
Yeah, I think it's appropriate to ask the applicant.
So I guess I was under the impression maybe the applicant would present the design plans or something like that. So I guess that's what you're referring to there, Connie.
And not specifically there. My understanding again was that we were looking at whether or not this would be allowed for the subdivision, and then during the procedure of the subdivision, determined whether it's a minor or a major. It would go through with additional public hearings if required. I'd have to pull back up if a minor, maybe an administrative review or a PCDC review. But at that time, the actual proposal would be reviewed.
We're deciding whether the subdivision can move forward or not. That's the question before the Board of Adjustments.
Okay, I had one more question. I was just sort of thinking through this. I think we've dealt with this in a separate case. And so my initial thought was, well, why not at least make one of the parcels 7,000? So it's, you know, fulfilled. And then the incremental parcel would be, you know, some subset of that number, right? So that in the future, if anything were to, you know, someone were to come to us and say, oh, we want to, the property's transacted, it's sold, we're 3 years down the, 10 years down the road, they want to put a porch on it, then the 7,000 unit is, you know, legit. And so I'm just, was that ever discussed, or is that thought through, or?
There was various discussion by the Board of Trustees and what they wanted to do for this procedure. It wasn't discussed for a specific application, and I'd say it's not what's in the code specifically to look at that as an option.
Yeah.
We're just a
mean,
number down,
Yeah.
and then the subdivision process is later.
You got it. I just was trying to get a little background there. And then can you just comment on the alley? Like what happened when the alley went in? Was this in 1930s, someone decided to put an alley there and that reduced down the property, or is that?
Right, at some point, the legal description has where I don't know, I would imagine that the town had to work with the applicants. I don't know if it was eminent domain and they took it back at that time, or if it was worked out that an alley would be beneficial, and so the alleys were put in and 10 feet on each side of the properties in some cases was removed for the alley.
Thank you.
Attorney Dittman, do you have a comment you wanted to make?
Yeah, I said the only kind of reason I could foresee why it'd be relevant potentially to say, no, it has to be yes, we will allow a subdivision to move forward in like these proportions is if you couldn't otherwise meet the requirements under the code, right? It was the only way to ensure that, the surrounding properties weren't affected or so on and so forth. But that could be a potential condition, but I think under typical circumstances, we would decide that during the subdivision process, not now.
Yeah, so just to be clear, this is a variance to an ordinance. It's not a variance to any structure or anything further down the line. So it's actually really limited in scope.
The variance to the process.
Yeah. Based on, it almost sounds like it's the Board of Trustees wanting another set of eyes on what their ordinance is trying to achieve.
But interestingly, and Connie was pointing this out, that some of the criteria that we're supposed to consider, we don't really have that information.
That's correct.
So,
Yeah, and just based on what Attorney Dittman said, to bring something up, are there a different set of setbacks for what's now called a subdivision? From a,
You would subdivide to two R1 properties, so they would have the same R1 setback.
But I would argue we do have that information.
Well, sorry, I'm so conscious of our recent training. We're supposed to be asking questions of Aaron, and we'll save our discussion for later.
Okay.
But Jim, if you do have a question, I didn't mean to chill your question, you should ask it. Yeah.
Okay, well, let me rephrase it. It
Great.
seems, wouldn't it, if we subdivide the lot, wouldn't the applicant have to live up to all the Lyons municipal code requirements in order to develop that lot? So we know that it wouldn't look anything more than what would be allowed in the Lyons municipal code, right?
Correct.
I guess my last question, Aaron, or potentially Attorney Dittman, is I saw in the letter from the applicant that they had talked about hardship and other things like that, public interest. But I didn't see those criteria those are common criteria for granting a variance, but we're not considering, are we still using those criteria plus the new ones or just the ones that are in the ordinance?
The one item it says, I guess, is
Because I'm looking at 16.3.150 D1. I guess it's 2A and B. Are those the only criteria we're supposed to be using, or also the ones that show up in like 16.14.70?
It does say shall find that all of the following criteria have been satisfied in addition to the variance criteria for approval as set forth in section 16.14.70.
Okay. All right. Okay, thank you, Erin. Any other questions for Erin?
I'm just gonna ask it, I'm gonna ask the question, I don't know if it's more suitable for our discussion, but is the town considering that this variance may, let's just say it gets approved, that then once the new structures are put in place, that it might be required to come back to this committee if the new structures are, supersede the existing rules. In other words, they want to put a certain size this way, or they want to extend a thing and it's not meeting the original town requirements. Is that something you guys thought about or talked about?
Right, in looking at the application, the applicant was made aware of what's required to do an actual development. Structure on the property, so they are aware of that.
Okay.
And that said that there'd be specifically be a need to come back for some other variance after that happened.
Okay,
But I'd say we don't know until if plans get developed. Right, part of it is the first step is can we even move forward and should we spend the money on the plans?
thank you.
Karen, has it been a three-step process? We consider the variance, others consider the subdivision, and then ultimately the development.
Not, well, it is and only in that it could be development can fall into, so we're clear, just a building permit. If it meets what's required for that. Most cases, a single family home is just a building permit in the R1 zone process, so there may not be what you think of as a development review process. It would only be the subdivision and a building permit unless there was a need for, that something was proposed that did not meet a building permit.
Thanks. And then one other question, is this our first time
Yes.
considering a minimum lot size variance?
Yeah,
Any other questions? Okay. Now I'll ask the applicants, Mr. Lee and Ms. Sobel, to present their application.
Hello, I'm Dan. So the lots,
Can
when,
you state your name and address, sir, please?
Daniel Lee. My address is 1735 Oak Ave, Boulder, Colorado.
Thank you.
My name's Tracy Sobel, same address, 1735 Oak Avenue, Boulder, Colorado.
So with the lot size, all the houses on that block are all smaller than 7,000 square feet.
well, this is the property.
Right,
size is
but if we
the
get
property.
it approved, they would all, it's not like all of a sudden this lot's tiny and all the other ones are bigger. They're all like, I'm pretty sure I'm right that all the houses on that block are below 7,000 square feet. I just want to throw that in there. And I think he explained most of everything that we're trying to build is a single family home on their lot.
Yeah, I want to say that we want to do a single family home, keeping it small in line with the rest of the houses in that area, because other areas of Lions houses have come in that are way bigger than was originally in Lions. And just a little background, we lived here for over a decade, for a long time. Our daughter was born on Main Street, in our house. We moved here when our son was a baby. And like I said, our daughter was born here and they both love this town. This lot we purchased, it used to be Jerry Fikes' property, and our son grew up playing with JT. And Jerry and our son and JT and our son had a very close connection, which is why we purchased the property when he passed away. We were connected with the family and connected with them about purchasing the property just because we were so connected with that family. My son used to play ball out on the stoop all day, every day, and Jerry would always stop and talk with him. He had his ball still like in his house because he thought he was going to go pro, and he said, "This is my retirement fund." And so that property always meant a lot to us, and we love Lions. We only moved out of the town because we were in an extremely horribly tragic accident. And couldn't deal with driving to work and stuff anymore, so we moved closer to work. But one day when we retired, we talked about coming back here. Our children want to move back here. Our son's getting married this summer. And that was one of the reasons we wanted to build another house, so that there was a place for them. And if they didn't come, we also would love to have just another small place, because we know after the floods, there is a housing shortage, and we wanted to be able to provide housing that people from Lions can afford, as opposed to renting to people from outside of Lions. And keeping it local and keeping it the charming town that it is important to us.
Anything else you guys want to add?
If you have any questions, I'm happy to answer them.
Questions?
Yeah, you know, I do have a couple questions. I purposely did not go look at the property, as sort of part of our process. So
I do have a picture of it.
there's an existing structure on the property, is that correct? And so, and you own the full property with the existing structure?
Yeah. Single family.
And you want to subdivide it into two separate lots?
The house that's on there now, the structure, single family home, is to, if you're looking at it, it's, I guess, to the east, on the east side of the property, so you could split it down the middle, and there's room on the opposite side to put another house, and we would take down that, somebody mentioned the stone garage, that would be coming down, and we'd be putting another small, single family home there.
Right now, it's like an overgrown field,
Oh, okay.
basically.
And I don't,
And I do have pictures of
is
it.
the intention to legally subdivide both the properties and then to either rent or sell one of the other properties to a different tenant? Or I'm trying to understand just the future, you know, possibilities of what this will look like. Is that the thought process?
The thought process is to keep them both as, each one having one single family home.
Okay.
A small single family home for a family. Right now in that house is a friend who's a single dad. And his kid goes to the schools here and he's, and so we kind of want to do the same thing next door, but our son had always talked about maybe moving back here, so there's a chance it would be for him as well, since he's getting married this summer and, you know, no children yet, but when they do, I know he always talked about wanting to live in Lyons.
And with each, would a consideration be to put a garage and an ADU on each separate property? And do you know if that fits within maybe the current code?
No, we're not planning on doing ADUs, because that code says you have to live in one of them to have an ADU.
Okay, and did you
So
guys
that's what-
consider making one lot 7,000 and then making the other lot smaller to at least adhere to whatever the current code is?
I assumed we had to make them equal because they're just shy of the 7,000 by a little bit due to the town taking over that area for the alley.
Yeah.
So I assumed we just had to make them
Well,
equal.
we assumed, because that's what we were told by the town planner,
Oh,
and then we were told it was approved, and then we had Flatiron Surveying come and they surveyed it right down the middle.
Right, because the original
But-
town planner a couple years ago, like you had mentioned, told us that it was approved. And
oh,
he told us to go ahead and get it surveyed, it's approved, and go ahead and, he's kind of set us forth in motion. We used to have plans, and those plans we had plans that we could have showed you, but that was 2 years ago, and those, we had to kind of let that go, because we just couldn't do it anymore. But yeah, I mean, if we were told we had to do one 7,000 and the other, we're open to whatever, we just wanted to.
one final question,
Well-
does the alley provide access to both properties as far as like parking? or
Yes.
where you- Okay, I'm done with questions, thank you.
We figured we would have parking in the
And-
back so that it wouldn't congest the street.
And so we did get a survey, you know, we paid the cost of that, which was, you know, $5,000. And then we did take out a loan based off of the planner telling us, emailing us, congratulations.
Go ahead and take your loan. So we did.
So now we've kind of been sitting on loan for,
All right,
and then I reached out to the mayor after the last vote and kind of told her you know, what was happening with it, and she's like, just be patient, because I was like, if it's not gonna work, I'll stop the bleeding, because I can't keep paying this interest on this loan. And so kind of the whole time they've been like, just be patient. So we've been trying to just be patient.
When you guys bought the property, what was your thinking at that time? Was it, you sort of bought it with the purpose of subdividing it, or you bought it thinking?
Originally, I thought it was 2 lots when we bought it, because that's what we were told. It looks like 2 lots on the map. And it was, like she'd said, we had a connection with Jerry Fikes, and a lot of people said it was gonna be condemned, it was gonna be torn down, it was in really bad shape.
I don't know if any of you had ever been in that house,
Like-
but there were chickens and lots of animals living in the house, and it
Like
was never picked
The
up.
fire department came over, like, what are you guys doing? I was like, oh, we're remodel, clean it up, and they're like, you need a hazmat suit to go in there. That was what, I mean, it was bad. And I know the neighbors, some over here complained about all the trash. I did 8 30-yard dumpsters of trash, and a lot of them were in that extra lot. Just,
He was a hoarder. to say.
and then finally the town came and said, oh, you can't have the dumpsters anymore. So then we started hauling just trailer load of the trash. And I had like, you know, the B guy and local people come and, you guys want the cinder block or anything usable, take it. All other stuff to resource, still 8 30-yard dumpsters of trash. So it was in bad shape. And then we did a small addition on, put a kitchen on. I put like $90,000 into that house to rehab it. And now it's a very nice house.
We were told it was a double lot, but we were really like. Jerry passed away and it couldn't go, so we were in touch with the family and it couldn't go to the kids. The family wanted to sell it and to give the kids the money, and so, I mean, we kind of just felt a connection to it because our son grew up hanging out there, which once we were in there cleaning it up, I could have.
Well, it had to be sold
We
as
don't know
is.
And it had to be sold.
You don't even get a loan.
I see it.
Any other questions?
You happen to know at the point at which you're planning to put the dividing line, what the setback would be between the existing house and that new line? I can't quite tell from the drawings, but I thought you might know.
I don't remember that. I think it's gotta be, it's got it. Over the setback.
It was about 2 years ago when we had those plans done.
It should be on the survey.
I'm
The
looking
land-
at surveying,
land
and it
survey.
may be hidden somewhere in all those numbers.
We knew the survey, when he came out and did the survey, he told us where exactly we could put it so that there was within the codes of what it had to be, and there was, it was definitely within the codes.
And I understand part of the code requirement is that each one has to be more than 6,000 square feet. That's why you couldn't make one 7, the other one would then be less. than
Right, I think
6,000.
they're both
Yeah.
roughly 6,700 square feet.
Right, so they're almost exactly equal the way that you've.
For, right,
Yeah.
and then like you can see the neighbors, I mean, how the houses are stacked on that street, they're all pretty
Pretty tight,
tight, pretty similar, they're all similar lots.
thank you.
And 3 houses down, like since we've owned the property, somebody did put a new house on a double lot down there. I don't know how they did it, but it was done.
Yeah, he's got it on a picture that, where you can see the lots.
Any other questions? From the applicants?
I know there's concern with some of the neighbors about parking, but the plan is to have alleyway access, a small garage. We would tear down the garage that's there, that's on, next to the house there. And put a small garage behind that house and a small garage behind the new house. So it'd be actually more parking than there is now.
Thank you. Well, thank you. I'll now open the public comment portion. to Allow members of the public an opportunity to address the board. Is there anyone who'd like to speak from the audience?
I'll speak.
Thank you. Just, when you get up here, give us your name and address.
My name is Alan Shealy. Address is 639 2nd Avenue. I'll keep this very brief. I'm just speaking in favor of the variance. I think it's a good idea.
All right, thank you.
Andrea Marshall, 218 High Street, across the street from the property. And I'm speaking in favor of the variance as well. I was so grateful that Dan and his wife bought the property in the first place. The other 2 bidders on the property at the time were gonna level the house because of the condition it was in and put up huge houses. And this has kept the neighborhood within, within a certain, kept the neighborhood sane with what it was, with what it looks like. And it's great because it actually, Janet, whose family had the cemetery can't remember the last.
Or back.
Orbach. The Orbachs, actually, her grandparents lived in that house, so it was historical that way. And so I'm very, it's beautiful what Dan has done with the remodel and extension with the new kitchen. He's done an outstanding job on it. I know that whatever he does on the property will be first class.
Thank you.
I would just like to note for the record, I did receive an email from someone in favor of this lot subdivision. I thought I had slid it into the folder and I cannot find that email, but I just wanted the board to know that we did receive just one email in favor of this, none against.
Okay.
Thank you. The applicants want to rebut any of the supportive comments that were made on their behalf? All right. Good decision. All right, does the board have any other questions of the applicant or the staff following the non-rebuttal? No. Okay, I'll now close the public comment portion of the public hearing in order for the board to deliberate. Please keep in mind that during deliberations, no further input from the staff, the public, or the applicant is permitted unless the board requests the clarification on a specific issue. The board member who would like to make a motion.
I'll move that we approve.
Okay, is there a second?
Second.
Okay, great. Discussion? Well, I'll start. I've been trying to figure out, I just started with what we know, and we know the criteria for variance approval under 161470. And I thought, well, maybe let's start there,
Yeah.
and then we can look at the new criteria that was added by the ordinance. And so just as a reminder for everyone, and I have it up if we want to look at it, we cannot grant it if it permits use not allowed in the zoning district where the property is located. I don't think that's an issue here.
No.
Is in the public right of way or on public property, not an issue here. Alters the definition of this chapter. Is other than the minimum that will afford relief with the least modification possible to the requirements of this chapter. So that is asking us if permitting the applicant to move forward with a subdivision application is other than the minimum relief or the least modification that could be made. So I guess maybe let's pause on that for a minute. This seems like a fairly modest variance because we're not granting a subdivision, we're just allowing them to move forward with a subdivision process. The town will ultimately decide if a subdivision will be granted. I think it meets that criteria, but I just, anyone has, because I know you asked questions, Bill, about couldn't we do an ADU that would allow you to have, two things on the property.
Yeah, but that would be the next
Next
variance.
variant, yeah.
Also, like, if they just were gonna redo the house or stick with one house,
Mhm.
they're already legally meet all the requirements for that, because it's 7,000 feet over, right?
Mhm,
So this seems like it will be the minimum
mhm.
to meet the subdivision.
Okay,
It seems that the next most similar solution would be to allow them to put two homes along that street on High Street, not front and back, but
mhm,
on the street front.
mhm.
And that strikes me as a greater relief, not a lesser relief.
Okay, I agree.
What do you mean not front or back?
Well, typically an ADU might contemplate a house on High Street and another one back toward the alley.
Right.
But if they were to put two similarly sized homes side by side on High Street, as I think they might be intending to do ultimately, that strikes me as another way that we could, or someone in the town could allow them to move forward with what they would like to do without a variance.
Right, with the only thing being that we're not making any judgment as to whether they're side by side or whatever that other house looks like or where it sits,
Or
right?
even if there's another house.
Or even if there's another house.
Mhm.
But I hear what you're saying.
Yeah, I'm just saying, if we were to make a decision that would help them to move forward with what they want to do, the only decision in my mind that I could imagine is for this board or another board to authorize the placement of another home on the property. But any way of doing that other than allowing them to seek a subdivision
Hmm.
seems like more of a burden on them, not less of one.
Okay,
Okay. But, unless I think we can move forward and we seem to have some consensus on that point. If based on the physical, so again, this is a negative, we cannot grant the variance if based on the physical conditions or circumstances of the property, they're so general and recurring throughout the district as to make it practical to form a general regulation to be adopted as an amendment, which is almost a
Well,
circular argument
right.
because the trustees have adopted an ordinance to address this.
Yeah.
And then brought us into it. So I think on that one, we'll just, unless, are you concerned about it, Bill?
no, I mean, we've had this conversation before in the past where we're like, we run into these scenarios and like, we really need the town to make a, make a new rule to, we don't have to do the variances.
Right,
But it sounds like we're covered there.
yeah, I agree.
And there's other properties that meet the similar characteristic.
Okay, the next one in this first bracket is, we cannot grant a variance if it's based on findings of personal, is based exclusively on findings of personal or financial hardship, convenience, profit, or caprice shall not constitute undue hardship. So I feel that in this particular case, the applicants were, even though they did give us some testimony about the financial hardship that this situation has caused, there were other factors that led them to this point beyond their just personal financial situation, including representations made by others in the community, in the town, and et cetera. But I just wanted to, that's a point of discussion. Mhm.
So you're saying that, if there was financial hardship, we can't make a decision based on that?
We cannot grant a variance just because, if the only reason,
Yeah, that's not the scenario here.
not the scenario. here.
Yeah.
Okay. All right, so now we're in part B. Thank you for working through this with me.
No problem. Well, thank you.
In order to grant the variance, we must find that all of the following have been satisfied, okay? That there are some unique circumstance or condition to the physical circumstances,
Yes.
such as irregularity, narrowness, shallowness of the lot, exceptional topographical or other physical condition particular to the affected property.
It's met because of the alley.
The alley, okay. And that chopped away part of their lot, which otherwise would have met the 7,000, okay. Because of these unique physical circumstances or conditions, the property cannot be reasonably developed or used in compliances with the provisions of this chapter.
True. Well, I mean, it could be developed just as a single family home,
So it could
but
be,
in spirit of what the town's trying to do and the infill strategy, it could not be met, so we have to make the variance based on that if we're supporting that strategy.
Which fits into the reasonably developed.
reasonably developed, right? Okay, due to unique physical circumstances or conditions, the strict application of this chapter would create a demonstrated hardship. I think that's been met. Do we agree? Yeah.
Yes, because the thought was we're buying two lots
Right,
and then the alley took away a portion of that lot,
right.
I think.
Mhm. The hardship is not self-imposed. Again, I think, if the applicants bought the property, with the understanding it was 2 lots and turned out to be 1 lot, I don't feel like that's self-imposed.
And maybe they were told by a previous board that this is gonna fly.
If variance if granted will not adversely affect the proposed development or use of adjacent property in the neighborhood. I haven't heard that allowing them to go through the subdivision process will adversely affect the rest of the neighborhood, so I think that's okay. The variance if granted will not change the character of the zoning district in which the property is located. Again, I think it's met that, allowing them to go through the subdivision process, which ultimately will decide whether or not there are 2 lots or not, is not out of character with the zoning district. I think the board, by saying they would permit 6,000 square foot lots in certain areas if you meet these requirements, has sort of already found that criteria. The variance if granted is in keeping with the intent of the code. Yeah, so. And will not adversely affect the health, safety, or welfare of the citizens of the town. All right, so those are our classic criteria. Now we look at the ones that the ordinance added. Some are similar.
I think down at section E2 or way down on page 3, the bottom of page 3 is pertinent.
Not sure which page you're looking at.
Are you looking at the
Ordinance, yeah.
1170?
No, I'm
Oh.
looking at 1170. I don't see a D2 in 1170.
But down at the bottom of page 3 is
I'm in 16.3.150. You're in 11.
oh, you're over this, you're still in the I pulled up in the packet, it's got the ordinance 1170 amending.
Okay.
Okay, I think that's actually what we're here for. That's the most
You're actually in
curious.
the same place.
So what exactly section are you on?
1170 amend 16.3.
Yep, bottom of page 3.
Where it says,
Variance for minimum lot size.
variance for minimum lot size, 1929 lots, okay?
Mhm. Yeah, that seems to be,
Yeah, so sorry, I'm just being clear. This is 16.3.150 D1.
up at the section 16.3.150, yeah.
1170 amends.
Ordinance, no, that's an ordinance. I'm talking municipal code sections. Sorry.
Yeah.
Okay, so we're in section 16.3.150 and you're at. Okay, now I'm with you, Joe.
Yeah.
Thank you.
Yeah, sorry, I didn't use the
It's all right, no worries.
municipal.
Okay, and so which code?
Look,
what are
go to
we-
number 2A and just
2A.
read down from there and you'll see the requirements below.
Yeah. But Joe, you had something in particular you thought was pertinent? I'm sorry,
Well, it just,
just the whole thing.
yeah, it is saying that, you know, a lot less than 7,000 square feet, such lot shall be considered as sufficient for the minimum lot development standard.
Yeah,
Connie, we could just read through those
Yeah.
and just make sure we're meeting those, I guess,
Yeah.
possibly.
that's a great idea. The lot to be subdivided is legally described standard lot for a double lot as recorded in 1929. That's what Aaron said at that criteria. It won't be subdivided more than once. Meets that. It won't be divided more than 2. I guess that means that they haven't gone through the subdivision process yet, so this is just their first go at it. And no resulting lot will be less than the 6,000 square feet, which that's the,
Yeah.
Okay. Now we have these other criteria. If granted will not adversely affect the proposed development or use of adjacent property or neighborhood. I think we already went through that in our classic
Yeah.
criteria. If granted will not change the character of the zoning district in which the property is located.
I mean, the best we could say right now is it won't, but,
Right,
and then if some, I don't know, some house or structure gets proposed that once it built, that doesn't, they may have to get a variance again.
That's right.
I don't know those codes, right?
It's just zoned, so you know it's gonna be built there.
Yeah,
It's R1.
Right, it's
Yeah.
gonna be an R1.
okay, there you go.
Not to be compliant, but
Yeah.
So it's
Yeah,
not gonna
right.
change that. It's not, we're not,
Yeah,
they're not proposing R2 or R3.
yeah.
So that's not changing. We're not saying anything along those lines.
the terminology of variance is a little bit. I don't know, I get wrapped around that a little bit. 'cause-
Agreed.
Yeah.
The only change that I see this variance making in the character of the neighborhood is a very small one. Where along that block, I think there are several of these open areas. And it will feel slightly different if those get subdivided and filled in. Where this would be the first and could be the first of a few. But we've heard from neighbors on their side of the street and on the other side of the street that they don't object to that change or even see it necessarily as a change. So I would say that's a de minimis change in their character, if any at all.
And I guess, for me, again, to Greg's point is, we're not being asked to say, will it affect? Should variance be granted that allows two homes to be built? We're just saying, should a variance be granted to allow them to go through the subdivision process?
Very narrow, very minimum.
I don't think this variance makes that change.
Yeah, that's what I
Yeah,
was thinking too.
okay.
Thank you. All right, well, allowing them to go through the subdivision process if affect the health, safety, or welfare of the citizens of the town.
No.
All right, so having gone through all of the criteria, is there more discussion or do people feel ready to go? Okay, so, I think the motion was to
Approved.
approve. Okay. It says to take a roll call, but can we just?
We can just call for the vote, yeah.
Okay, I'll call for the vote.
And that motion passes unanimously.
Yay. I'll let you guys know tomorrow the next step. As long as no disasters come up that have to work on the utility side of things.
Right, okay, let me finish up here, this one part. The variance request submitted by Daniel Lee and Tracy Sobel. Yes. For 217 High Street is approved by a vote of 6 in favor and none against. And the public hearing is closed at 5:44 PM on this matter. Do we keep it open because we've got the second matter?
Now we can start all over.
Start all over, all right. Okay. Any other regular business items from staff? Or reports? No,
Congratulations.
Thank you.
Right for the second item?
Now
No.
the second.
The rest.
Right around, we're gonna take a quick break and allow for.
Dan.
How long of the recess are we taking?
Quick 5-minute break.
Yeah, 5 minutes.
Thanks.
we're live again.
Okay, I'm gonna call to order the February 27th, 2025 Board of Adjustments meeting at 5:50 PM. Dolores, could you do a roll call of all members?
No, we don't need to
We don't have
start
to?
all the way.
Okay, it's on my
Yes.
script, so I
Okay, sorry.
All right, let's see, okay. The second application on the agenda is the variance application submitted by eCamion Inc. for setbacks and screening variance for an EV charging station to be located at Sandstone Park. The item is scheduled for a public hearing before the board. The purpose of the board adjustment is to consider variance requests and appeals for administrative decisions and considering an application before the board must hold a public hearing, allow for certain procedures in order to conduct a hearing that's fair, impartial, and orderly. As a general rule, the individual speaker is given 5 minutes to speak. Applicant's primary representative will have 10 minutes to speak. Subsequent speakers representing the applicant may speak for up to 5 minutes per speaker. The board may ask questions of the applicant staff or speaker at any time. If there are members of the public present to comment on the application chart, board will generally allow each speaker up to 5 minutes. Board discourages repetitive testimony. Hearing vote for members is necessary to reverse, modify any decision and determination of the town approve a variance application. I'll now open the public hearing on the variance request for EV charging station Sandstone Park. First, are there any disclosures or recusals from members of the board?
Full disclosure, I sent an email to somebody in the group that's seeking this to do this project, asking them what kinds of ports they were going to have as an EV owner, but that's it.
Thank you for your disclosure.
And I guess I could disclose that I attended the EV charging meeting, public meeting last Thursday
Okay.
at the library.
I think there is nothing in those disclosures that causes me any concern. Is Brandon still here? Well, he's not here, Susan.
Yeah, I'm still here.
Yeah.
So I was gonna
Ready?
bite to eat while we were on break. And so it's up to individual members, not the board or me, about whether it causes a conflict of interest. But so long as you both believe you can determine it in an impartial and fair manner, there's no need for recusal.
Thanks. Okay. Now we'll hear from Director Aaron Kaplan, give us an overview of the case.
So this project began also a couple of years ago with the presentation of the possibility of getting the faster level 3 charge station in town. It was looked at from a perspective of what would be the best location, what would be the most appropriate around town. And then once Sandstone Park was determined to be that location, there is already an existing EV charging station there. So the process looked to be pretty straightforward with putting a new EV charging station there. The qualification with this project is that this has the beneficial aspect of having battery storage to its project. And this battery storage unit has to be placed in the Parks and Open Space property of Sandstone Park, as opposed to being in the right of way, which is where the EV chargers are. So the town code did not have any allowed use for EV charging stations in any zoning. So an ordinance was passed to allow EV charging stations and any required additional needs to build the EV charging stations, such as the battery storage, with the certain requirements for the various zoned properties. And in Parks and Open Space, I believe it's in all of them, but we are focused on the Parks and Open Space. And I know in that one of those requirements, it does have to go to a conditional use review. So it will still be going forward for this project. The next step will be the conditional use review. But part of those conditions are a 25-foot setback from all the property lines. Again, when the ordinance was developed, it was looked at for all the properties in town and other parks where you might want to have that 25-foot distance in Bone Park or somewhere else that's not this particular location. And then also there was the requirement put in for screening of electrical boxes, battery banks, and solar hoods as required. So the applicant is requesting to do a custom wrap on this battery storage unit, which was part of the original proposal. And the location was also part of the original proposal. When this ordinance was passed, it was known that this would then trigger this project to come forward with the variance request. Think that covers all of it. And we have again the ordinance where the code was listed for the conditional use. But I think that, I don't know how much you need since that was in the cover memo, that it's a variance from the setback and a variance for the screening.
The screening references the wrap, Aaron,
Yes,
which is tended to be like an artistic.
correct. I wondered if that was. Probably not there, if it was in one of them, but yes, it will be an artistic wrap if you've seen some of the way the current, they've been painted, but it would be similar to the transformer boxes or electrical boxes that you've seen painted in town.
It's just a visual screening, and, because I've heard some stations when they kick on can be kind of loud-ish when the transformers kick on.
I haven't,
Visual, not auditory.
that's correct,
And not safety related.
correct.
So just to make sure I understand, we're being asked for two things, two variances.
Yes, if it's separate, I didn't know if it's, they're two separate items, yes, if that's two variances.
I have a question. So just so I understand, so the request for the 25-foot variance setback is to put the power pack located in the park. And by giving the variance, we're allowed to move it closer to the road.
Correct.
Okay, and then the fencing. So the fencing requirement is only for visual blocking, not for safety for kids running around the park. That's a big issue here. We're right. I mean, if we need a fence because we don't want kids running up and hitting that box, then that's one thing. If we're just trying to hide it and we're gonna make it look pretty, then great.
So I think the setback is to allow it to be 10 feet from the road or from the property line rather than 25 feet. And that is the desire to not impact the town park as much by going in. There are the tree location. It was difficult to find a location that worked and fit with what was needed. Some of it is at this location, we do have the post office across the street, the fire department across the street, as opposed to residential's right there. And as for the screening, I don't know specifically when they developed the screening, they did call it as screening more than safety precaution in the development of the ordinance. So in looking at it, in this case, it was looked at as the fencing there was more for visual effects. Again, I don't want to speak for what the trustees were doing when they did do that ordinance. But that would reduce the amount of space in the park, and that this unit there, as is a transformer, and there is a transformer in is the same box type unit that wouldn't have a safety concern any different than the transformers that are around town already without screening or bollard.
One clue to the intention behind the screening, it's not dispositive, but it's a clue, is that it says walls, fences, or flame resistant plantings to provide complete screening from normal eye level. As if it were aesthetic. It doesn't say that's the only purpose.
Okay.
It does point to that purpose.
Well, I know, I just want to make sure we don't grant a variance for a safety fence.
Aaron, I'm sorry that I'm asking something you've already said, but the town was aware of this proposal when they created their new ordinance. But they nonetheless were still required the 25-foot setback. Okay.
Right, and you'd ask why, I would, again, asking, going back to the, some of the logistics of the other one, trying to understand what they're creating and what process that's gonna entail before it comes forward. And again, me trying to also understand the variances. Do you create things knowing you may need to have one or two get a variance? Because in general, you want it to be standard, but there may be sufficient reasons. That's what they come to do, is to show why the variance should be granted.
Aaron, do you think the applicant would be able to clarify the fence concept for us?
Yes.
Okay.
Any other questions for Aaron? Jim? No. Great.
Nope.
Thank you, Aaron. And now I'll ask applicant to present their application.
Didn't bring a presentation or anything.
That's okay.
Yep, I'm Diane Dandino.
Oh, can you give us your address?
Yes, 197 Second Avenue, Unit B, Lyons 80540. So I am a Lyons resident. Also, I am the owner of iPower Alliance, and we are the installation contractor partnering with eCamion to do this project. And so we have been working with the board and presented it's been an iterative process of answering a lot of questions and coming to a design and location that was generally accepted in terms of concept. And then it was like, okay, now you enter our process. And this process came in with the setback. We did spend a lot of time, first of all, the value of a battery box and a battery makes this project possible for us, because we basically don't have the power available for 450 kilowatt level 3 chargers, which are needed in the town of Lyons for both travelers and locals to be able to charge their cars if we need high speed charging. So this is a real benefit to our community, but also as travelers come through, they'll stop and shop and do other things. So, and the battery makes it possible, and that allows us to slowly charge the battery through our existing 50 kVA transformer and then fast charge the cars. So this type of solution was the only one that really probably would have worked for us, and also consulting with UEB evaluating it. So it kind of went through all these different pieces of analysis. So the battery location, there's a few pieces. We want it as close as we can to the chargers because it's really expensive big wire. So the closer it is to the chargers, the more cost effective the project is, and it keeps it all together. We have to, for code, we have to have it 10 feet from the road, so cars don't potentially drive into it. So that's why it couldn't be in the right of way where the other chargers would be. So that we had moved back 10 feet. So then looking 10 feet and the area of the park we'd have the least impact, that was this location that we have selected, which is 10 feet back, kind of nestled between the trees. And it's an area like where people won't be sitting to watch the concerts because they couldn't see it. And so the location seemed to be sort of the best for least impact to park users, good location for powering the chargers. And so that's why that site was selected. So that's main thing. And then once we selected the site, we were told, oh, you have, this ordinance came out at 25 feet. Come and talk about why we've selected this location. We think if we go 25 feet back, that's where the picnic table is. So we wanted it's a good location for that. The other part we talked about was part of the process too, was talking to the Arts and Humanities Commission, who was all excited about, hey, let's put some artwork on the box. The box is safe. It is, maybe some high voltage signs on it just to keep people, kids away from it. But it's a safe piece of electrical equipment. It is designed to be safe on the outside. So it is not, there is a little bit of, there's an air conditioner in it, and there's a little bit of an air conditioner hum, but you walk 10 feet away from it, you can't really hear it. So that's the only sound. And again, I read that if we had to put trees around it, we could. If we had to put a fence around it, we could. That's not a deal killer for the project, but it was a lot of enthusiasm for the Arts and Humanities Commission to put some visuals on it to, like they were talking about, oh, let's put on it's like the history of transportation, because that's what this park is about. So it's kind of bringing in more of the spirit of the community into the project. And that's why we were talking about doing a wrap. So those are the two pieces of the project why we're asking for the variance. So that's my presentation.
And you had in your letter the specific reasons for each of those that you guys have also.
Any questions for the applicant by anyone on the board? Okay, thank you.
Thank you.
I'll open for public comments. What else? Does the board have any questions? Does the board have any questions, the applicant or the staff?
We did have the one letter in support. That's in the packet.
Yeah. Do you have a question or?
No.
Okay, just a reminder. Thank you.
I have a question for staff. I just want to clarify this. The second variance, it is a variance to not put a fence or a tree or something around it? Or is it a variance allowing them to paint the box?
The variance to not put the fence or screen in.
All right. Okay, got it. Thank you. I make a motion to approve the,
Oh, wait, hang on. I think I have to do something. Okay, now close the public comment portion of the public hearing. Order for the board to deliberate. Keep in mind during deliberations, no further input from staff or public applicant is permitted unless the board requests clarification on specific issues. Okay.
I make a motion to approve both variances.
A second.
All right, discussion. We go through our list again, probably go through it faster than we did the last time. Reasons we cannot grant it. Permit to land use not allowed in the zoning district. If we can, criteria is okay, is in a public right of way or on public property. Well, it is gonna be on public property,
Yeah.
but I guess it's allowed because of the ordinance.
Yeah, it's a different intention here.
Yeah.
It's a public. You could reverse it and say it's not on private property.
Right, yeah. Alters definition of this chapter, no, is other than the minimum variance that will afford relief with the least modification possible to requirements in this chapter. So we could say it has to be 15 feet or 20 feet, or, you have to do the 25.
Yeah, but in this case, it's putting the project further into the public domain,
Right.
and it's increasing the cost of the project with wiring, so. Yeah, it's perfect,
Okay,
and it's meeting the 10 foot away from the road, so a car doesn't hit it.
right, okay. Is there any more discussion on that point? It's based on physical conditions or circumstances. If it were so general and recurring that we'd have to ask the town to make a change. I mean, I don't know how many EV charging stations are gonna be put up in the town of Lyons. This seems like a unique issue. That's why I was concerned about the fact that town knew that there was gonna be this project. They knew where they wanted to put it and they still put in the 25-foot setback.
I think all the town did was they put in that it's an allowed use in the ordinance. The ordinance didn't change the 25-foot back for everything else. So it's not specific to the charging station, I don't think.
Well,
I think it may
it
be,
is specific.
I think
to
it's in the
charging
ordinance.
station. It's in the 1610-100. All required infrastructure shall be located at least 25 feet from all property lines, specifically in the EV charge station.
Well, it is.
I'm guessing that they put a general rule in there to keep it away from people's houses
Okay.
or stuff like that, and then come to make an exception.
And just to make it kind of the same as everything else, right? I mean, yeah.
Okay, there's no logical thing for us to say, oh my God, that's gotta be 25 feet.
Yeah, okay.
Doesn't really make sense in this.
Chair
case.
Ister, Attorney Brandon.
Yeah,
Oh.
Attorney Brandon.
And just to clarify too, the ordinance was contemplating, different types of uses of chargers, not just like ones in public right of way, but like charging banks that are off the public right of way. So, and which obviously would not require a setback, variance. So it's not just this type of charger, it's all different types of chargers. That's contemplated by the zoning code change that was made.
Thank you. Okay, and, we can't grant this based exclusively on findings of personal or financial hardship. Obviously, this is a public utility, so probably okay. All right, following things have been satisfied. We can grant it if we meet all these criteria. There's unique physical circumstances or conditions, which is whatever exceptional for this thing. Seems like, well, it's a park, it's got trees and the road and, seems like they did make an effort to find the right spot. What do you think, Joe?
But not what we're here to talk about, but like
Well, I mean,
other spots that could go, but that's not.
But I mean, the unique aspect of it is that it takes the batteries to provide the fast charging, and so the battery pack's gotta be close. So that's the positive uniqueness of it, right? I think.
Yeah, no, that look was just, it was just odd to put it in the park.
okay, there is a charging station near there now, right? Yeah. Okay,
Yeah, it's
Well, that,
it's in the existing.
About the merits of the siting. I mean, is that really what we're here?
No,
No.
No,
That's
that
not
was
your
Joe's
purview.
point.
no.
yeah, but no, I mean, like, that normally we think like, oh, well, there's this big tree we don't want to cut down, or, the lot is so small, there's only so many options, this is a big park, there were potentially a lot of options, but I think there are these other conditions about it has to be 10 feet away, it has to be close to parking, it has to be, away from where the public would be when they're watching the concerts. So maybe there are some, I think we could probably meet that criteria, but I'm open for other discussion. Strict application of chapter would create a demonstrated hardship due to the circumstances conditions. So strictly saying it must be 25 feet setback. Would that create a hardship?
Yeah, I find it, it'd be expensive and the charging capabilities would be diminished. I think,
I think
distance.
I'm thinking more it create an issue with the park and the
Oh, yeah.
concept, stuff like
Yeah,
that. So in
I
my mind, it's better to have it where it's.
Totally
where
agree.
it's being proposed and push it off into the park and use up more park space.
Yeah.
Right.
Agreed.
Are we only talking now about setback, or are we also talking about screening?
Oh, I forgot about the screen. Thank
The
you, Lee.
screening strikes me as less of a hardship, but still an impairment of the park.
Right, you would be keeping the character of the area. Thank you for reminding me.
Seems like it would also increase the area that would
Footprint.
be impacted.
Oh, if
Yeah.
there's fencing.
Is there fencing?
Yeah.
Yeah,
If you do look around town, they've got all this other kind of all these other, transformers and stuff like that in the parks. And so it kind of follows that this is gonna be bigger, but it kind of follows that, the Arts and Humanities, Commission would like that.
Yeah,
And it does reduce or increase the amount of space that's available for other uses in the park versus screening.
okay, the hardship is not self-imposed. To me, it feels like this is really, looking out in the public's best interest, all these decisions and considerations, and they're really not about the applicant's needs, and they're more about the community's needs. The variance of grant will not adversely affect the development or use of the adjacent property or neighborhood. I don't think wrapping the thing or putting it where it's gonna affect the fire department and the post office or that closer it is, it's probably better, right? Is in keeping with the intent of the code. Right, and then won't affect the health, safety and welfare. That's to your point about the fencing. The applicant said, you know, it doesn't really need a fence to be safe, so probably okay. Everyone feel okay about that? Okay. All right, any other discussion or comments or anything before or people feel ready to take a vote?
I'm ready.
Yeah. Mhm.
Do we have a list of the people who were given notices? Was there a fire referral?
You can ask Aaron.
I'm trying to pull up, right?
What does that mean?
Whether the fire district was
It is a list in
notified
there.
of this.
Public notice signage. I don't know if they were given.
Part of the reason I ask is that there's a fire hydrant immediately across from that corner
Yeah,
where firefighters often drill. There's a lot of water that gets sprayed on the corner diagonally from where this battery is going to be. And I wouldn't be the person to say too close, too frequent. I think it is far enough and infrequent enough that it might be a non-issue. I just take some comfort in knowing that the fire district got a glance at it.
just in spirit of discussing that, this container would have to be completely waterproof, right? I mean, rain, snow, melt, flood. I mean, the fire department doing some training over there, I don't think it's gonna be the biggest impact from weather to that system. That would be my guess.
That's also my guess.
They are on here, the Lions Fire Protection District.
Good enough for me.
Okay.
Okay,
Well,
Also
I
the-
think just for the record, they were on the public hearing notification, so we do a 300-foot radius of where the project is. They get notified, but I don't know that a true referral was sent to them with the application. It may have been during other steps of the process, but I don't believe that went through with the variance itself.
Right, we don't send out referrals for a variance.
But there will be later in the
conditional
process
use.
a referral.
To the
Yeah.
conditional
Sounds
use.
like.
But they were.
also the
sent-
town would need to tell us like, hey, we're asking for a variance, but we think that 10 foot's gonna create a danger versus 25 foot. So, I mean, usually the town would come in and give us a suggestion, so. I mean, I think based on the information we have, we're covered.
Okay, all right, if folks feel ready for a vote. Call a vote on the motion to approve both variances, the variance regarding the wrap and the variance regarding this setback.
Yeah, actually, the variance for setback and the variance to not put up a fence.
Right, the wrap,
Okay,
yeah, I'm
Alright.
sorry, yeah,
yeah, right.
okay, all in favor?
And the motion passes unanimously.
Okay, the variance request submitted by Camion Inc. for a new charging station located at Sandstone Park is unanimously approved by the board by a vote of 6-0. Public hearing is closed at 6:19 p.m. Dolores or Aaron, are there any other regular business items scheduled?
No.
None that I
Before we adjourn, I just want to give one thank you to Joe, who indicated he might be leaving our board. He's done an amazing job. It's really been a valuable member of the board.
Maybe come visit the next one. Over there.
Part of the process.
And then.
Now you're free to request adjustments.
Along those lines, I'll just mention, a number of us have been on the board for some time. I'm happy to continue serving, but we're well overdue with our term. It's just that because there's additional vacancies that haven't been filled, we just keep on keeping on. And so, if anyone knows of someone who would like to be on the board, please encourage them to
Okay.
apply, because we have, if Joe goes off, we'll have 2 vacancies.
Oh, okay.
And we need a vote of 4, and we'll only have 5 folks, so if we, you know, a lot of times it's hard to get all 5 of us in one place at a time, and then it'll have to be unanimous vote, which is usually unanimous anyway, but,
Okay.
yeah. So, all right, that's my regular
Is
business.
that all right for us to do that and go find some folks?
Oh, absolutely.
Okay.
Some people would say it's Joe's obligation.
Yeah, Joe's got to replace his job. Good evening.
I so enjoyed. During the meeting,
Yeah, it's like fun.
6:20.
Thank you, Diane.
I just want to also thank you all for your service to the town.
Oh, thank you.
Appreciate it. Yeah, so thanks a lot. We'll see you in the next one.
Yeah, we'll see you later.
Okay.
That's great.
Great, thank you.
Hey, we adjourned?
Yeah,
You're
we're
welcome.
adjourned, and Laura can make it.
Did you find anything about the lot consolidation, Brandon?
Yeah, it's not good news. We do need to move to adjourn though.
Oh.
Do we need to move, or I usually just say we're adjourned?
I make a motion to
Okay.
adjourn the meeting.
Okay, adjourned.
Do we need to vote on that?
Yep.
Yep, okay.
He said yes.
Hit your button.
You're gonna give me more work now?
Yes.
All right. What do
Yeah,
we gotta
Aaron,
do?
the bad news is it probably requires a rezoning,
Great.
which I don't agree with, but that's what the
Rezoning.
consensus is.
Thanks, Brandon.
Yeah, thank you.
Good night, everyone.
Nice to
Thank
see
you.
everybody.
See y'all later.
So out at the new development across the street, they
Bye,
have,
Dolores.
they have the
Bye,
town
Joe.
right of way property.
Hopefully I see you.
Road right
I'll
of
try to see you
way,
more now.
One of the new generator development property, you know, where the he's building across the street from us.
Playing together this year?
Where he's got it,
I think
yeah,
so. I
right
was
in front
not
of Public
sure,
Works
but
across the street.
my kiddo.
He's
is
got 2 properties
19,
that
and
are
Are we
said
good?
different zones.
Turning it one year, and we can
And
play
it was
together.
just supposed to be a simple lot consolidation, but because there's a
Nobody
zone, now there's another process.
Oh,
Like, this thing with Diane should have been done
Are we
a
good?
year or
Attorney
2
Dittman?
ago, and now this is the
Yeah,
first
I
step.
was just see if Aaron wants to continue on this topic or
Okay,
not.
gotcha.
She's now gotta do additional, and then she's gotta do development. And I'm like, this is.
Yeah, I know it's coming up.
just-
Aaron, we can talk tomorrow if you want, but basically the advice I got was you can't rezone a property without a hearing. And so if you were to consolidate, you're effectively rezoning one of the properties. And so you couldn't do that.
Okay.
I don't like it either, but I think that's what we have to do. That's what we have to do.
Yeah.
Just what I mean, more process,
How's,
legal and planning, that's my new role.